All right. Hey, everybody. Thank you for joining us today. I am very, very excited about this topic, and I have so much to learn. And I think that is why many of you are here as well. And if you have questions, please know that the folks that are joining us from the Law and the Future of Learning team are eager to have a conversation and to share what they have learned and the work that they're doing based on the things that you're bringing to the table as well. So please do not be shy about using the chat or unmuting if there are things that we can address in the moment. That is what they're looking for, and not necessarily just to wait until the very end for those questions. And so I'd sent out a form. I think some of you may or may not have seen it, but if you had a question that was like lingering or you just didn't get a chance to ask it, please use the chat to do so. Or again, feel free to come off mute and weigh in. So with that, I'm going to hand it on over to our friends with the Law and the Future of Learning team.
Thank you, Molly, for that kind introduction. And thank you, everybody, for being here. I was going to say, I know this is a busy time of year, but there's not like a not busy time of year. So we really appreciate the folks who are here in person and the folks who are joining in the recording later on. So maybe we'll do quick introductions and then jump into it. And as Molly says, I think the conversation will be the best part. So I'm Will. My title's a mouthful, but I'm the director of the Open Knowledge Center at NC State, which means I'm the lawyer in the libraries, and I get to do all the fun open stuff, including for the past decade or so, open education in particular. And I'm super excited to be part of this team. Meredith, do you want to introduce yourself?
Sure. Hi all, thank you for having me. My name is Meredith Jacob. I work at American University's Washington College of Law, where I, like Will, talk to people about copyright, fair use, but really specifically, I think our work together and my work specifically is about taking the big world of copyright law and talking about it in the plainest everyday language possible. That this stuff seems super complicated and super high stakes, and it occasionally is, but it often isn't. And I think, our work is really focused on helping people understand where, in sort of normal, low-risk ways as part of their work, they can make some decisions, and that it can help them do more, right? Have more interesting materials, share things than they otherwise could. And
hi, everyone. Oh, I'll go.
Basically,
Meredith.
our team is all Merediths, except for Will. So we have Meredith Graham.
Yes. Hi, everyone. I'm just really excited to be here. Thank you, Molly, for having us. I'm Meredith Graham. I work at the Data Science and AI Academy at NC State. And my work is to lead our research initiatives. And so I met Will and Meredith when we were working on OERs together, and another job that I had. And so I'll segue that to Sarah, who also worked with me on the OERs. We cannot hear you, Sarah.
Yeah, Sarah may be on mute right now. I know she's doing double duty as well. So, Sarah, if you feel comfortable saying,
yes.
Yay!
Okay, I was on the wrong mic, I think. Okay, cool. Good. Yeah. Hi. Thank you for the introduction. Yeah, I'm a librarian, and for this project, I work as like the digital asset manager and sort of like project manager with the Law and the Future group. Thanks for having us.
Yeah. Great. So thanks everybody for the good introductions and for being here. As Meredith and several folks said, we have some information to share with you, but I think the best part will be the questions and the discussion. So please, early and often, pipe in with those. Say more about that. No, we all know that. Shut up and say something else. That's going to be the good stuff. But what we thought we would do to get started, and I'm going to see if I can walk and chew gum at the same time here. Are folks seeing my screen?
Yeah, we're seeing your full view of the slides, not the slideshow view.
Okay. There we go. Perfect.
And now we see the slideshow view. We are doing great.
Hooray. Thank you, Meredith. We're a good team. So we use this framing about making copyright as your superpower because as Meredith said, this is a universe that can feel stressful and uncertain and high stakes in certain ways, but what I think we really want to suggest to you today is two things. First, copyright, although you can spend a lot of time and build a career in the nuances as we have, at base, it's relatively straightforward. And more than that, if you have anxiety or fear about copyright, if there's a sense that like, if I do something wrong, the whole world's going to explode, or I'm going to lose my house, or things are going to go bad, I think the main message we want to give you is that copyright is a system that loves the work that you do as librarians, as educators, as folks who make the world a better place. Our colleague Kyle Courtney likes to talk about library copyright superpowers, and I like that framework, because it's the case that copyright is a system that's designed to support the public good for everybody. And one of the ways it does that is it carves out special spaces for non-commercial, educational, library and archive, for the society serving stuff that we all do. So what we thought we would do is to give you sort of an overview of the landscape of how copyright fits into our work, with a special eye to the superpowers that we have when we're doing that stuff. So I'm going to start out with a bit of an overview of things. Meredith is going to jump in and talk specifically about sort of where the rubber often meets the road with fair use and those other exceptions. And then I hope we will either leave a lot of time at the end for questions and discussion, or even better, weave throughout this conversation some of those questions and discussion that you have about the real issues that you're dealing with. Something that I've been thinking about a lot is this new set of requirements around accessibility that we're getting this spring and summer. And so that's an example that I thought I would use to ground this conversation. Yesterday, somebody came to me and said, oh my gosh, I need to scan all these books to provide accessibility. How do I think about copyright in that place? And that gave me an opportunity to do the thing I love to do, which is to talk about this toolkit that a lot of us in the sort of copyright library education community use, which is these 3 questions to answer any copyright questions. And you're going to see in each of these some of those superpowers that I've talked about. But when you get any sort of copyright question, whether it's about scanning for accessibility, whether it's about showing a movie in the classroom, whether it's about building a new educational resource, I want to commend to you this framework of thinking through, is there any copyright here in the first place? Question 1. Is there something in the law that has carved out special space under their exceptions and limitations for me to flex my copyright superpowers? And then failing those, is there space for me to rely on permission from the rights holder in different ways? So as we talk through those 3, think about how they work together, and think about how the work that you do fits into that. So to start at the beginning, that first question, is it protected or not? This is where I get to tell you what I said a minute ago, which is that copyright is not that complicated at base, that at some level, copyright is about the right to make copies, right? And there's more than that, but at some level, that's the baseline of it, that copyright happens automatically. We like to say that copyright follows the pen, that as ink flows from the pen or fingers tap on the keyboard, copyright exists, which means that if there is a thing in the world that is original to you, is creative, it comes from your own sort of creativity or imagination, and other people can see it or hear it or perceive it in some way, it's protected by copyright. We're going to unpack that a little bit, but what that means is at base, the question, is there copyright here, is often a pretty straightforward one to answer. Am I reproducing, sharing, engaging with in some way someone's existing work? And is that work protected by copyright or not, subject to those terms? Now, having said that, it sounds like everything in the universe is protected by copyright. That's not the case. In fact, the first sort of space I want to talk about for carve out that matters for the work that we do is that copyright doesn't protect ideas, facts, words, or short phrases. It only protects the expression of ideas in different ways. So that's the reason, for example, that you will often see these funny knockoff Halloween costumes, the Hermione Grinder, the top student at Chogborts, right? J.K. Rowling can own the story of Harry Potter and the books that she writes, and in some senses, the characters that appear in those stories, but nobody owns the idea of a young person going off to wizarding school. Nobody owns the idea of a lazy guy having shaggy dog adventures in different ways, right? So there's this huge space when we're doing the work that we do to borrow and build on the ideas that people share, the facts that make the baseline of the world around us, right? Nobody owns the G chord.
Does Will seem frozen for other people?
Yeah, hopefully he
Okay.
comes back.
Well, we'll wait for Will to come back, but I'll freelance this for a minute because Will and I have given this presentation a number of times. So I think what Will is saying here is that nobody owns the ideas in those expressions.
Sorry, as an is. Yep.
Okay,
Question?
you're back. I was mad-libbing where you were when you were frozen for us.
Oh,
We didn't hear you from the G chord onward.
okay. Thank you, Meredith, for saying that. So I'm back. I'm sorry for the technical issues. I was just saying that because copyright protects expression but not ideas, a lot of the informational resources that we use in the world are not protected by copyright. So I've got this example of a chart or graph here that comes from the discipline of history, but that's true for a lot of tables of contents. That's true for a lot of charts and graphs and resources and informational materials, libguides and that sort of thing. You often don't even have to get to the is this fair use, exceptions and limitations stuff, because copyright just sort of isn't there in the first place. A second limitation on copyright is that copyright, like Lana Del Rey, is born to die. And that's a feature, not a bug of the system. That copyright exists for a certain amount of time as an incentive to get people to share their stuff. But after a while, all copyrighted works pass upward into the public domain. And that means that every year we get this new wonderful class of materials. There are some great presentations that have come out recently with people remixing or building new things with the new set of works that enter the public domain. But if you're doing work on William Shakespeare or early 20th century silent film or any number of other things, the public domain is a space. And we can dig into the specifics of that more. For now, thinking about works that were first published in the US after 1931 in the US is a nice sort of shortcut to that. And if you have to become a copyright detective, this link, this chart out of Cornell is a nice place to go to get into the meats and bounds of that stuff. That's a rabbit hole we could go down very, very deeply, but for now it's a nice example of the top line stuff. The 1931 date is relatively straightforward and easy to understand. A third thing that we want to say, particularly as we anticipate some questions and conversations about artificial intelligence, is that copyright requires human authorship. So there are these long string of amazing cases where people said, you know, although I held the pen, the Holy Spirit entered my mind, so the Almighty should be the author of this work. Or I found this beautiful piece of driftwood. This is a sculptural work where the ocean is the rights holder. Or more recently, there was this sort of whimsical case about what they call the selfie monkey, a monkey who picked up a camera and started taking pictures. And in all those cases, courts have basically said only human created works are eligible for copyright protection. So there's a lot of interesting stuff out in the world that we don't have to talk about copyright because a machine or a crested macaque or the Holy Spirit created it in some sense. Maybe that's enough to say about the sort of the is it protected by copyright stuff. I start with that because it's an important foundation and because it lays the groundwork for a system that says copyright exists for a particular purpose, to promote the progress of the science and the useful arts, and it intentionally carves out a lot of space for us to do the society serving stuff, the everybody needs access to this stuff that we have talked about. So the question that I had yesterday, I was able to say, hey, good news, this book was published before 1931. It's in the public domain. Go forth and scan and be successful in that way. So that's that first part of the equation. Is there copyright in this place? And that's your first question if you have a copyright problem that you need to solve. Very often, though, you're dealing with a work that does have some sort of copyright attached to it. And that brings us to our second question. And this is really the superpower part. This is the superhero origin story piece of it in some sense, is that copyright is a body of law that has said explicitly, we are envisioning certain uses that we think are societally valuable. And so we want to carve out space and say, whatever else the law says, if you're an instructor, if you're a librarian or an archivist, if you're a teacher in some way, we're just going to make some special space for you. And an easy example of that is one that we all rely on anytime we do any sort of face-to-face teaching, is in Section 110(1) of the Copyright Act. Congress basically just said, teachers, instructors, librarians who are doing instruction, don't worry about copyright. Just if you need to perform or display a work, if you want to show a movie, if you want to play a song, if you want to have students recite poetry or take a part in a play, just do it. Don't worry so much about copyright. And that's representative of a fairly large swath of exceptions where Congress has just basically said, this is socially valuable, copyright shouldn't get in the way. So that's a nice example of those superpowers that we mentioned a moment ago. There's a similar sort of set of superpowers for librarians in section 108. This can get a little bit more complicated. So for now, I'm just going to sort of gesture towards it to say this is another example of a case where Congress has said, and the courts have affirmed, when you're doing this sort of recognized socially valuable stuff, we're just going to carve out some space for you so you don't have to have the anxiety get in the way. Most of those exceptions are created initially by Congress, and so they are designed to have a specific set of anticipated users. You're a librarian or you're an instructor, and they anticipate a certain set of behaviors. I'm going to do interlibrary loan. I'm going to make copies for preservation, etc. A lot of the action when we talk about copyright, though, actually happens in this interesting sort of exceptional exception space called fair use. And I think this is my opportunity to turn it over to Meredith to talk some about sort of what fair use is, how it fits in with the non-commercial educational stuff and library and archive stuff that we do, and how it might fit into your work as well. So Meredith, maybe without further ado, I'll pass the baton over to you.
Great, thank you. And so Will talked about how there are certain specific educational exceptions in copyright, or exceptions for certain specific purposes like preservation. But one of the really good things about copyright law is that it also has this big flexible limitation and exception, which is fair use, which is pretty important because, as we started out saying, copyright law covers a ton of stuff and it's automatic. So we get this sort of big, heavy blanket of copyrighted stuff, the sort of that we have to operate inside of, right? Every long email you send, every selfie, every newspaper article, it's all out there. And if every time you wanted to do anything with copyrighted stuff, you had to have a formal licensing transaction, you'd be really stuck. But there is, in fact, this understanding that we've made this really big, strong protection. And so we need to have a really big, strong limitation within that. And in the US, that's fair use. And kind of the next slide, Will. There's 4 factors for fair use. You always often hear about the 4-factor test, but fundamentally, there's really one core question for most of the stuff you want to do, which is, did you do something new and different, something transformative with what you are using? And if the answer to that first question is yes, did you use what is, roughly speaking, the appropriate amount for your new use? And this lets fair use do a huge amount of work in the system. When I talk to folks in education, and the next slide, Will. When I talk to folks in education, the first question, though, actually is one that isn't really part of the law, but it's where you need to start. And that question is, what is your pedagogical purpose for using this copyrighted thing? Because if your core question is, am I doing something different? You can't answer that question. You know, if a kid comes up to you, your 4-year-old, and comes up to you and says, is this different? Is this different? What's the obvious response to that? Well, different from what? Right? Like, is it different? Is not a question that you can answer without knowing the answer is, well, is it different from what? It's not like, is it hot? You know, it's a comparator. And so for educators, that is stating your pedagogical purpose really specifically. So one question I have here in the chat is if we could talk about a couple examples, if you could throw something in the chat of when you've wanted to use some outside real world thing in an educational material you were creating, in an assignment, something that was out there in the wild outside of your classroom that you wanted to get to use in your classroom. And if anybody, or in a educational resource you are creating, in an assignment, in an open educational resource, in any of those examples, was there anything you wanted to use, like a clip or an article or a picture or a poem or a street sign, anything like that? Because I'm hoping a couple of those will pop up, but
if we're waiting, Henry Heights to Fitchburg might be a good one, and I like this one a lot if you'd like to use it. Yeah,
we had that. I was just hoping to see if you bubble up, but yeah. So we were talking to some folks who were high school English teachers, and they were teaching Thoreau, and they had assigned, in this case, a read aloud of this children's book, Henry Hikes to Fitchburg, and they had said, well, we're going to have the students listen to this read aloud and then point out where the themes of Thoreau get sort of highlighted in this children's book. And we were talking about it. We were saying, okay, so is it transformative? And the question is, like, what's the pedagogical purpose? And they're like, well, the purpose is to get them to think about how to talk about those themes or conceptualize those themes in their own language, right? Not to be able to just quote from like the literal words in the book, but like to how to actually like reword them for themselves and identify them here. And they were like, it's that really specific thing. And I was like, okay, yeah, that seems good. And then every once in a while, someone says something so important that you like carry it with you. And I was like, okay, so why do they need to use the whole recording? And this very nice teacher looked at me as if I were one of her B- students. I was like, well, if the work is figuring out where the themes are, they need to look at the whole thing, right? Like if you find them for them, if you had cut them down to just the few excerpts where the sort of language or themes from Thoreau had carried forward, you would have done the work of the lesson for them. And so that was a perfect example. She could explain the pedagogical purpose of sort of forcing students to identify these same themes, but in a different wording and a different type of language, and then also to find them in the book. And so that was a perfect example. A couple in the chats here are talking of using clips of songs to show figurative language. That's a great one. And so if we were doing that one, I would be like asking you as like your colleague, and we're thinking this through, and I'm like, okay, so you want to use this clip, and why is it a good clip? And you might tell me, well, it's a good clip because it shows this type of figurative language really well, and it's an example of figurative language that students can understand in their daily life, right? And that's how you'd explain it. So that's a really good specific pedagogical purpose. And then the transformative question would be like, was this song written to illustrate transformative language to students? The answer to that is clearly no, it was not. And then the question is, are you using the appropriate amount? And that could be that you want to use a big chunk of the song or the whole song so that students have to identify which pieces are figurative language. Or it could be that you'd use a short clip because you're just showing them as like an introductory material, this is what it is. But it's being able to say those things out loud and understand why this is the right thing to do for your pedagogical purpose. And so looking through the examples, the ones where you can talk about the pedagogical purpose and that it is different than the original is going to be really important. So we have one there where a teacher is struggling because there aren't the right types of curricular materials and they're not sure about format shifting. And so there you'd have sort of two questions, which is taking a material and just scanning it to use for the same purpose. You'd need to make sure you had some permission or clear reason. That's often not fair use, with the caveat that in some accessibility situations it would be. But if you're creating new material that just draws from different sources, that certainly can be transformative. Taking material that was intended for a public sort of entertainment purpose and pulling up pieces for an educational purpose. Did that create more questions than it answered, or did it answer some questions?
Well, and I want to underline an important thing that you said, Meredith, which is that I think there's often a sense that people feel safe in the educational materials space, but entering popular materials, popular culture feels scary because it's like I'm outside of my comfort zone. But in fact, as you say, fair use is strongest when you're taking something and using it in a new transformative way. So you should feel especially confident taking a popular song, a movie that everybody's talking about, right? We want to bring K-pop Demon Hunters into our classroom to engage with it in different ways. That's where you're more often going to see those transformative uses, because those are things that are created in different ways. So another space where the point of greatest anxiety might in fact be a point of great strength.
Yes, I think in some ways fair use is strongest when the purposes are really different. And so that lines up there. On the next slide, we have another example of fair use here. This is a law school blog, and it's using just this meme for sort of emotional, like an emotional moment of connection. And the part there is that, fair use doesn't always have to be serious. Humor and parody are also legitimate. And if here you're trying to communicate sort of an emotional connection and not this isn't using the show for its original purpose, that could also be fair use. Next slide, please. And this is true even in sort of large commercial contexts. So the pictures here are from a famous copyright case where someone made and sold a coffee table book with all of the original Grateful Dead promotional posters. And there was this litigation over it. And they said, look, these posters were made to promote the concerts. They were made to get people to go and see the shows and to sell the music. Here, we're selling them in this, coffee table book that talks about the history of the band. And the court said, no, that's fair use. And it's important to be clear there that the different purpose is the real question. It's not just a question of, are you using a very minimal amount, or does have you gotten permission? It is, are you using this for a new, clear, very understandable purpose? And we said this at the beginning, your purpose needs to be more specific than for education, right? All of your purpose at some level is for education, but what we're asking you is, what is your specific pedagogical purpose or instrumental purpose for this material, right? Are you illustrating a point? Are you showing some pedagogical step you want your students to understand? So that's a really good question. It's fair use if you're using it for a new and different purpose that it wasn't intended for. So what, fair use says is, I can't go out and use excerpts of, so there's 6 psychology textbooks out there. And I'm like, wow, these books are all really good. I'm going to make a book that's just like a mashup of these psychology textbooks and take 3 chapters from this one and 2 chapters from that one. That would fail the fair use test. That would not be fair use. I would need permission to do that because those books were all created to be psychology textbooks. And my new thing was doing the same thing. So fair use says, if you are using something for a new and different purpose that's not related to the purpose it was created for, that can be done often without permission.
Quickly, Meredith, I'm sorry, but
I would say that it's important that there is, in a way that is not ever going to be entirely explicit, there is this sort of socially useful gloss for that it puts on the table. So if, for example, you came in and you said, I'm using this, Disney movie poster to promote my class on whatever, they would maybe be like, well, you have a trademark problem, so there's that. And then also separately, a court was probably going to be a little more skeptical of that because you're using it for sort of the promotional purpose. But fundamentally, the ability to use copyrighted things for new purposes, new socially beneficial purposes in education is often a question of, are you using it for a new and different purpose in which its pedagogical purpose is contextualized?
Yeah. Thank you, Meredith. I really like this case in particular because this is a lot of what library folks do often, is you take materials from the real world and you create a reference source or an educational resource. These were posters that existed in space. I want to talk about history over time by incorporating these real world examples. That's a lot of what scholars do when they make scholarly monographs, but that's also if you're making a LibGuide, if you're making a sort of an overview of a topic. This feels very analogous to that to me. I also like this case because there was a very active licensing market in place. I'll sometimes get the question, well, sure, if nobody's paying attention, maybe I can do that. But what if there's a license? Does that foreclose my ability to rely on fair use? And in this case, not only was there a license, the author reached out and asked about a license. The rights holder said, yes, you can certainly have permission if you pay me this insane amount of money. And the author basically said, well, no, that's totally unreasonable, and I'm doing something transformative. And the court agreed with them as well. So this is a nice case for go forth, librarians, and do your library stuff. But it's also a case about don't let the fact that somebody has their hand out demanding money lead you to believe that, well, I guess I have no other choice. I just have to pay them, because there are plenty of people who will happily take your money, even if they are not legally entitled to it. So I also wanted to take a minute to talk briefly about one particular library and educator superpower that I really value a lot, that dovetails with exactly what Meredith was saying. There's a specific section in the law, and it's in 504C2, section 504C2, that basically says in plain language, if what you are doing is likely to be, or you have a good faith belief that what you are doing was fair use, they are going to, the language they use is remit statutory damages, which means they take off the table any big money damages. So making my library guide on the Grateful Dead, I borrow these concert posters and I include them in my LibGuide. I get sued. I'm going to win, one, because there's this court, because there's this case already. But even if I were to lose, if I had a good faith belief that this is fair use, if I said, no, I've heard about this Grateful Dead case, and that's why I, in good faith, relied on fair use, courts would say, okay, well, even though you're wrong, even though you have lost the case, you still don't have to pay those big money statutory damages. You just might have to pay what they call actual damages, which is like you should have bought the posters for $20 or something like that. So that hopefully lowers the temperature a lot when you're making decisions based on whether a use is fair or not. Hopefully it can sort of reassure decision makers in your context as well. And it also lowers the incentive for somebody to sue you. Right, we like to joke about how litigious Disney can be, for example. But if the Walt Disney Company lawyers saw an instance where somebody was making a use that it seems like there's at least a good faith belief that it's fair, and they were doing the calculation of should we sue them or not, if best case they were going to get a $20 bill from that person, let me assure you, Disney's lawyers make more than $20 an hour. So the economic calculus changes a lot as well. So this is one example of a space where Congress has said, not only do we want fair use to be there for everybody, not only do we want to acknowledge that the non-commercial educational library stuff it sort of exists at the high point, at the greatest point of strength in fair use, we want to even further sort of create those superpowers by giving this special type of protection for the non-commercial educational institution, library, or archiving, as they say here, stuff that we do. And one really, really good way to articulate that good faith belief, both to find good practices, but also to say, this is why my belief indeed exists in good faith, is to rely on these resources called the Codes of Best Practice and Fair Use. This is a project that's been going on for a couple decades at this point. There are codes that are created generally by speaking with many, often hundreds and hundreds of practitioners in a particular field to talk about what does responsible practice look like? What does a good faith, thoughtful librarian do, or visual artist do, or journalist do in different ways? And then that leads to a set of best practices that are then vetted by a set of very, very respected and well-known attorneys to say, yep, that's what the law should say as well. I want to point to those because there's a code of best practice and fair use for academic and research libraries that I use at my own institution when I'm working with library folks. And then more recently, a code of best practice and fair use for open educational resources was released. This is a great resource if you're making open materials, but even if your materials are not open, if they are educational materials, this is often still a really good guidepost for making good faith, best practice decisions about when uses are more or less likely to be fair. Meredith, you obviously are work very closely on a lot of these projects. Do you want to say more about the codes and what they might mean in this context?
Sure. I think fundamentally what the codes are is a way to take these questions about copyright. So Sarah put 4 statutory factors for fair use in the chat: the purpose and character of the use, the nature of the copyrighted work, the amount, the effect of the market, which are very abstract and are like pretty hard to apply, and for which honestly, you know, they're weirdly a bad starting place. They're good guideposts maybe, but the starting place has to be in understanding your practice. And what these codes are is a way of understanding which repeated questions and problems come up in your practice and how to approach them in a way that feels repeatable and relatively low effort. So for example, if you're a music teacher and you go through the process of understanding sort of when and how you feel comfortable using one clip from a musical performance to show a technique or a musical characteristic, then once you've done that a couple times, you can sort of rely on the same big framework to not have to sort of start at first principles each time. And these codes are sort of a field-wide effort to say, here are some repeated problems, and here's how to think through them from a copyright standpoint.
Yep. I think that's very well said. I think another thing that's true is those 4 statutory factors. And I'll note that the text of the statute says, consider these things along with other questions. So those are often the 4 that people point to, but they're not the only ones. Those often are legal questions. And the thing I really like about the code and the framework that Meredith is talking about is it starts with a practitioner question. It doesn't ask an educator to say, well, from a legal perspective, is this, the appropriate amount and substantiality of the work? It says, what would a good educator do? Is this good pedagogical practice in different ways? And that's a question that those folks are really well situated to answer. Is like, yeah, a good educator would take Henry Hikes to Fitchburg, would read students the whole thing, and then have them do the work of identifying the pieces that refer specifically to Thoreau, right? So instead of sort of starting on our back foot of like, okay, if I imagine I were a lawyer and I was making an argument for a judge, the third factor would say this. It really grounds it in the experiences and the expertise of the people involved. And I think in an important way, that's a superpower as well. That's the law recognizing when what you are doing sort of exists in this safe, privileged space of non-commercial, educational, instructional, librarian, et cetera space. There's a lot of deference given to the professional expertise, to the pedagogical expertise as well. And these codes are valuable because they start us, as Meredith said, in that familiar and repeatable space rather than in the sort of, if I imagine I'm a lawyer, what would the argument be space. So returning to the hypo I gave us at the beginning, and I'll ask you this, Meredith, my colleague comes to me and says, I need to make some scans for accessibility. Will talk to me about the public domain, but that's no help at all, as usual for Will. Please help me. How does fair use fit into this? How would you help them think through scanning a book for purposes of accessibility using the transformative analysis that you've talked about?
Sure. It's a bit of a trick question, I think, in part because transformativeness and the sort of question of like, what is your original purpose? Like, what are you doing this for? What was it originally published for? And are you using the right amount? Is certainly, if the answer to those questions is all, clear, then it is fair use. I think questions about accessibility actually go farther than that. So there were a series of cases about a project called HathiTrust that was scanning large numbers of books for accessibility. And what we found out from the decisions, is that when you're acting at the intersection of 2 big areas of fair use, one, the sort of traditional fair use we're talking about here about transformative, and the other is sort of the substantive pro-social commitment to accessibility, that you're at the sort of highest possible sort of strength of the fair use doctrine. And so here, I would think about the questions we talked about. What was the original purpose? What's the new purpose? But I would also think about that market harm factor. There's a code of best practices in there, that in that list that Will showed, that was talking about best practices in fair use for orphan works. And those are works where you can't identify the copyright holder. It also talks a lot about works that were for a sort of short-term ephemeral purpose. And so I think with accessibility, if I were in charge of a big accessibility project, I would sort of sort my stuff out. I think one question is, are you scanning only to make materials accessible or to sort of give digital access to all students? That would be one question. Obviously, digital access for all students is more valuable, but scanning for accessibility for students with disabilities is a sort of more narrow, clearly defined purpose. So that'd be one question of which are you doing? And I tried to do the first one whenever I could, but I might do the last one in situations in which I felt like my fair use analysis was sort of narrower. And then I think the question would also be like, what is the material? Is there an easily accessible digital version that comes in a format that meets my needs in terms of student access and accessibility? Or is this something that we've been using for years? There isn't a digital version. It's a sort of supplementary material. And then I think there's a stronger scanning justification for all students. Well, what would you say about that?
No, I think that's exactly right. And the HathiTrust language that you mentioned, it's the judge uses some of the most colorful, like, I cannot imagine a version of fair use that would not permit this sort of scanning, right? This is, Meredith, you talked about this as being sort of at the intersection of two of the strongest areas of fair use. So if you have any anxiety about scanning for accessibility, I would urge you to release that anxiety and go forth and do the good stuff that you know you should under your mission. This also falls into one of the categories that my general counsel's office likes to talk about as which case would I rather defend, right? If I'm facing down a choice between I'm getting sued by a publisher for making scans for accessibility, or I'm getting sued by a student because I'm not meeting my needs under the ADA, I know which case I'd rather defend. I'd rather stand up to the publisher and say, I'm sorry, let's fight about copyright, but this student who has accessibility needs is having their needs met, than tell the student, sorry, too bad for you. You can't participate fully and equally in our classes because it might make Pearson mad, right? Like there's an equity piece there, there's a PR piece there, and that's recognized by the law as well. So that sort of mission-centric piece of it, I think, is important in addition to all the good stuff that Meredith, that you said. So if the first question is, do I even have to think about copyright? And the second question is there a part of the law where I have a superpower that I can rely on? And Meredith talked about fair use in really thoughtful ways. I thought the last question to ask yourself is, well, if the answer to those is there is some copyright and I'm moving beyond the bounds of what I feel comfortable with in terms of those exceptions and limitations, permission always cures anything with copyright. If you can reach out to a rights holder and get permission from them, that always solves everything. That can happen in very informal ways. There's a famous case you read in law school about two people at a bar who sat down and sort of hashed everything out, writing on a beer-stained barroom napkin. And the court said, yep, that's a contract. So you don't have to have a formal, fancy, notarized document with a bunch of weird Latin phrases at the bottom. If you have a message that other people can see, even something as simple as an email that says, yeah, please go forth and do that, you're in good shape in terms of permission. There's also this wider world of permissions that are grounded in an open license. And I wonder, Meredith, if you would say a little bit about open licenses as a form of sort of blanket permission and the Creative Commons as the signal way that tends to happen.
Sure. Folks in the chat could drop in with heard of Creative Commons licenses, so I would know where to pitch this. That'd be great. But the Creative Commons licenses are standard open copyright licenses. They were put out there to deal with the problem that everything in copyright is all rights reserved by default. That other than the limits on copyright, like fair use and the fact that ideas aren't protected, that other than that, the sort of the built fence is the default. And so the Creative Commons licenses are a way to say, look, I didn't create this because I was going to sell it. I want to put it out there for other people to use. Here are the standard terms. If you meet the terms, you can use it. And so it's basically the equivalent of open source software, but for content. And there's a large body of educational materials called open educational materials that are available under this license. And they're a really good complement to fair use. Because as we talked about earlier, if you're using something for a different purpose, your fair use justification is high. So if I want to teach about the history of the Vietnam War, using, New York Times articles from the 60s and the 70s are very likely to be fair use, right? Even though the New York Times will sell you a license for those, using those historical articles for a teaching purpose is a very sort of classic fair use. On the other hand, using a history textbook for that purpose, making copies of that is very unlikely to be fair use because history textbooks are being used for the same purpose. So the flip side is for that modern content, for that content that's meant to be teaching content, the Creative Commons licenses can cover that.
Thank you, Meredith. Yeah, and to say the CC has a search space that you could go to find a lot of different stuff. You can filter Google Images for CC licenses. There's also, people sometimes don't know, there's a bunch of openly licensed music and film as well. So if you're making videos and you want some inspiring music in the background just to set a scene, you could think about fair use in some cases, but there's also sites like CC Mixter that have a really nice set of music and similar as well. We probably don't have time to dig into all the nuances of the impact of terms of use and terms of service, but I tend to point people to the terms of service didn't read to understand if I'm borrowing content from a lot of online sites, what that might mean. I also wanted to briefly recognize that there are these PROs and intermediaries out there that if you need to think about permission because you want to show a Hollywood movie and it's not for classroom use, that would be permitted by that 1-10-1 face-to-face teaching exception I talked about, but for a fundraiser or an evening movie night for everybody, that you can reach out to folks like Swank for movies or BMI or ASCAP for music, etc. And then there's also the reality that when we use existing platforms, sometimes they bring their own sets of expectation about when we can and cannot do things. And YouTube's Content ID is a very commonly encountered version of that as well. So I think, looking at the clock, we have about 10 minutes, which is what I was hoping we would leave at least for some questions and discussion. Before we jump into some of the questions that we heard ahead of time, are there questions in the chat that we want to make sure we have a chance to get to?
From what I'm seeing, Will, a lot of it has been kind of answered from what was currently there, but anybody that is like a pressing question right now, this would be a good time to ask it. One thing that I know gets asked a lot, and you kind of touched on it with the monkey selfie and the Holy Spirit are not necessarily who can be copyrighted, right? Same thing goes with AI, correct?
Yep.
Yeah. So
yeah. Meredith, go ahead, please.
My answer to that is yes, but don't get sort of down the rabbit hole of like overly formalistic there. So if you go to Midjourney or ChatGPT and go, make me the thing, right? Make me this thing, and you just like put in a prompt and it spits it out in fact, that thing is not protected by copyright. The flip side is it doesn't mean you can't use it. That just means if someone else uses it, you can't turn around and sue them for copyright infringement. So in most situations, though, that won't matter. So if you're just creating stuff that's sort of background illustrative stuff for your classroom, like, I can't think of a good example. Like, make me a picture of a bear riding a jellyfish in a police car as like a funny slide to like start off a lecture, or like, rewrite this historical passage in like this sort of like text speak, or like, slang, right? Like something like that that's sort of humorous. Yeah, sure, you can do it. It's just not protectable by copyright on the output. And so that's not a big deal. And then I think there's sort of this ethical norm that might be in a situation where someone was confused, you might want to make sure that people knew it was created by AI. And then in other situations, if you use AI as a sort of brainstorming tool, then I wouldn't be particularly worried about that. The question is really, did you write the sentences yourself in large part? You know, is the sort of core creative work yours?
Yeah, I think that's excellent, Meredith. There's a famous case early in the 20th century where somebody took a bunch of photographs and the claim was raised, well, you didn't create that, the camera did. Machines can't own copyright, so no copyright in photographs. And the photographers shot back, like, I did use a camera as a tool, but painters use a brush as well. So, we don't say that there's no copyright in paintings because the brush made the artwork. I think that the standard today is exactly as Meredith said. The outputs of purely AI generated works are not protectable by copyright to the AI, but if the AI outputs something that already is substantially similar to something that existed in the world, that doesn't wash away the underlying copyright as well. I think we're going to start to see courts in the next few years wrestle with what happens when there's a 7,000 word carefully created prompt and then there's reprompting, right? What happens when the AI starts to be used not just as a push the button and see what the machine spits out tool, but as a truly artistic tool? So the answer today, the Copyright Office has been very clear. AI can't make works that are protected by copyright in a way that the AI makes a claim to it. But I think that question about different types of usage is one that's going to be bubbling up and in conversation in the years going forward.
The other thing I think, sorry.
I was just going to say, my school library brain goes like, it would be really interesting to have a debate or at least a conversation with students about that. Like if you prompt something and it creates a really cool image, that who owns that image, right? Like kind of giving them that like little bit of a prompt to get them to be thinking about it and then load it the other way, right? So a lot of times that we can ask AI to make something that most likely was a copyrighted, or trademarked thing. Now it's getting better, right? And so those of us that have played a little bit with image creation, you can't say make a Hogwarts character, make a Disney character, right? Like most of them will say that is a trademarked item. And so it's teaching you, right? It's teaching you a little bit, which is helpful. But I just think that there's these opportunities to get students to think a little bit about both sides of that coin. And then how would you feel if, you wrote a prompt and it created something and you looked at one of those other 20 Chromebooks and it's almost the same, almost the same image. Who gets the credit? Like having kind of these little debates and conversations could be quite interesting. I did get a good question in the chat. I don't know if y'all saw it, but Joanna asked one that I know a lot of people think about. So switching gears a little bit would be, what's the difference between showing a video that's owned by the library versus one through a streaming service? Because we see a lot of teachers doing that, asking about it. So I think that's a great one to bring to this table.
Yeah, it's a really, really great question. Because it's not one that has a very satisfactory answer. So section 110.1 explicitly says that when you're showing movies in the classroom, what they call it audiovisual materials, because the law is old, they say that it needs to be a copy that is lawfully made. So the idea is you can't just go out and buy a bunch of bootleg movies and show them in the classroom necessarily. So when I license something from Netflix, Netflix is giving me a license to use it. So in a sense, right, I have lawful access to that movie and I should be able to show it. But the terms of service that Netflix provides basically say this is only intended for your personal use. This is intended for you to watch in your house, or maybe you and your family watch it. They do not expressly license, and at least some readings of the language suggest they are intending to not give you permission to show to larger groups of people. When folks have asked Netflix about this and Netflix reps about this, there have been cases where somebody said, hey, Netflix, I'm a teacher, is it okay? And the Netflix rep has said, absolutely, of course, we love that. There have been other cases where they have asked Netflix and Netflix has said, of course not, you could never do that. So that's left us in this weird sort of space of uncertainty. My own answer to that is, well, we're recording this, so I'll say I would be intentional about thinking about the risk that might be involved and who might become aware of what's happening in your classroom. And I would acknowledge the fact that Netflix doesn't offer institutional licenses. I talked about those PROs. If you want to show a movie that Swank has access to, they will pay you for that stuff. But if I want to show a Netflix original film, I can't license that at any price. And so I think educators are often in this space of going, The purpose of the law is to support educators, right? We're supposed to be superheroes in this space. Nothing in the law has changed to make that impossible. It's just that Section 110.1 was written in 1976, and so it's kind of outdated, and it didn't explicitly address what Netflix is doing. And Netflix is sort of creating this intentional ambiguity about the question. So as educators, yeah, please.
Sorry, no, go ahead.
No, please, go ahead.
I'll say that 110.1 isn't your only recourse. To the extent that you're showing a film, like if you're showing a film because it's raining at recess and you want to like, keep everybody inside, or like, you had like someone didn't show up that day and you're like, we're gonna watch some movies, then I'm not saying that happens in the fine public schools that you all work with, but when I was in school, occasionally you watch some movies for which the pedagogical purpose was, I would say, fairly abstract. And in that situation, 110.1's a good choice. But if you are discussing the details and you're really digging into a film from Netflix and you're talking about how it relates to the material, that could also be a use that was covered under fair use. And for what it is worth, fair use does not have the legal copy requirement that 110 does. So you absolutely could consider whether showing that film to discuss it would be fair use, even if you didn't fit within the technical part of 110. The other important thing I think this leads into is that copyright is an economic doctrine, not a moral one, right? Copyright is about who you have to pay when. And so there's lots of situations professionally, whether it's in citation, whether it's an understanding of plagiarism, where you have to give people credit for all sorts of ideas or inspiration that you don't need to pay them under copyright law, right? So if you do a bunch of research, and a lot of your research is based on somebody else's ideas and their research, you absolutely need to cite them, right? You need to say, my inspiration for this topic came from here, my specific ideas came from here. You might teach your students that it's, really important to cite your sources and show where you got stuff and say when you used AI and tell where your ideas came from. Those are different professional norms, and they're based on the community you're working in and the type of work you're doing. And they're really important. What they are not is the copyright law, which covers, do I need to pay someone for this? So fair use is the economic law. It is the piece about money. And then the question, I think, separately about credit and permission, credit is separate from permission, and saying, this is where my ideas came from, this is what I was inspired by, maybe I used AI to create this. All of that discussion is really a parallel world from the other piece. And as Will says, big companies like Netflix specifically benefit from this ambiguity, where they don't have to pick the fight of not letting people use the movies, but they don't have to create a second licensing scheme. And so, it's a complicated place that we put schools and libraries in.
Yep. That's really good. And that I notice we're right at the top of the hour here. So I am happy to answer more questions, Meredith. I bet you would be happy to as well. But if that's where we leave it, I think that's a great place to leave it as well. So welcome to hang out and chat some more. But if you need to run off, you won't hurt our feelings as well.
We could also
please, respond to our form if you don't mind pointing people there, Meredith.
Yeah. So Meredith Graham dropped a Google form where you can put in questions and anything you'd like to see more training or more resources on. It's in the chat. Feel free to share that with anybody. Whatever information is put in there, we're not like publishing names and questions. We're just using that to inform the stuff we develop. I don't think you even have to we don't have a place for you to put your name unless you want to put your email address in the bottom. If you'd like us to follow up, we will, but it can be anonymous otherwise. Another thing I was going to say is, I don't know about Molly's schedule, but I think we could stop the recording if we wanted to and stick around if people wanted to unmute and sort of, talk through some problems in person, as it were.
Yeah, I'll do that now. I'll stop the recording. So if you want to stick around, you're welcome to ask the questions.